This is a special meeting of the Nevada Unified School District Board of Trustees. It's October 10th. Please rise for the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, the board did meet in closed session this evening. I'll have Trustee Aguila report out the closed session items.
Good evening. Items that we discussed in closed session pursuant to Government Code 54956.9, conference with legal counsel, pending litigation, Coalition to Save San Marin versus Nevada Unified School District, Marin County Superior Court case, number CIV 1702295.
Information.
And that was information only. And second item of business to be discussed in closed session was pursuant to Government Code 54956.9, conference with legal counsel, anticipated litigation, and that was information only.
Thank you. Moving on to approval of our agenda this evening. It stands as is. I need a motion.
I'll move to approve the agenda as is.
I'll second.
I have a first by Trustee Mack, a second by Trustee Aguila to approve our agenda. All those in favor? 6-0, 1 absent. And Trustee Millerick is not here this evening. As you can see, it was just a logistical thing, and he's just unable to make it. He had a conflict and could not get out of that. So he's sorry he cannot be here. But we do have our quorum present, and we're ready to go. We do have non-agenda public comment on our agenda this evening. If you'd like to speak to an item that's not on this agenda, please fill out a blue card, and I will have you speak immediately because we're right at that point. If you are speaking to the item that we are discussing this evening, the San Marin lights, I already have some blue cards. Please fill one out, and there'll be an opportunity to speak during the item as it gets presented. I will open it up to public comment, and then I will go through the cards. You have 3 minutes to speak. Please come up to the podium when I call your name, and the 3-minute timer is right there, so please stick to the 3 minutes. If you go over, I will ask you to wrap it up if you could in a few moments. So, all right, I do not have any non-agenda public comments, so we will move forward with our presentation this evening, and I will turn it over to Yancey Hawkins.
Thank you, President Butler and trustees. First, I would like to introduce our team here tonight. We have Bryce Chastain, our CEQA attorney. Bryce. We have David Deitch, senior biologist from Rincon and Consultants. And we have Jim Benya, our lighting expert from Benya Burnett. Jim's right here. The second thing I would like to thank the staff at NUSD, especially Ashley and Ellen, for the very hard work that they've done to get this massive amount of work done. So thank you on that. So first, I'm going to walk the board through the process of how we got here today, where the board will consider the certification of the final EIR for the San Marin Stadium Lights project. In the spring of 2016, the district took over this project from a group of parents and boosters and hired Rincon Consultants to draft the EIR for the San Marin Stadium Lights project. In August, an initial study was released along with a notice of that release. In September, a scoping meeting was held at San Marin, and based on the feedback in that initial study, a draft EIR was released in December of 2016. There was approximately 2-month public comment period, as you might remember. That public comment period included a public hearing to hear comments on the EIR, as well as a trip to San Mateo to review a similar project that was completed down in San Mateo. On May 16th of 2017, the board voted to certify the final EIR. And on May 30th of 2017, the board voted to approve a statement of overriding considerations, approve the mitigation plans, and approve the project at that time. That was the end of the original EIR. In terms of the partially revised EIR and the final EIR that is for consideration tonight, there is also, I want to bring the board and the public through where we got through there. In June of 2017, a group of neighbors filed a lawsuit in the court of Marin to challenge the final EIR certified on May 16th of 2017. From September of 2018 through January of 2019, construction went through, and the project was substantially complete as of January of 2019. At the end of January, the court ordered the district to revise and recirculate a narrowly focused portion of the EIR, and that became the basis of the partially revised EIR that you will be considering as part of the full EIR tonight. In April, the board approved Rincon Consultants to draft the partially revised EIR, and at this point to bring in a lighting expert, Benya Burnett, to support the effort. On July 24th, a draft of the partially revised EIR was released for public comment for a 30-day public comment period. On August 24th, the public comment period ended, and on October 7th, the final partially revised EIR was available on the district's website and sent to interested parties on that October 7th date. And here we are, October 10th. A reminder of the four narrowly focused areas that the court ruling as well as the partially revised EIR are focusing on. The first one is aesthetics, including lighting impacts. The second is biological resources. Third being alternatives, and the last being cumulative impacts of the project. These topics are extensively discussed in the final partially revised EIR. So, staff is recommending the approval of Resolution 17-2019-2020, certifying the final EIR, which includes the final EIR that the board approved in May of 2017, as well as the final partially revised EIR that was available on October 7th and is in front of the board members today. Some key points, to be clear, not all of them. Obviously, the resolution is very long, but a few key points that I'd like to read right now in the certification of what the board is being asked to do. So staff is recommending that the resolution is stating, the final EIR for the project has been prepared in compliance with CEQA and CEQA guidelines. Number two, that the final EIR was presented to the board, which reviewed and considered the information contained in the final EIR and comments received during the comment period. Number three, the final EIR reflects the board's independent judgment and analysis. And number four, the findings made in the resolution are based on the information and evidence set forth in the draft EIR and final EIR and upon substantial evidence which has been presented in the record of these proceedings and the final EIR and all supporting material. So these are just a few of the key points from Resolution 17-2019-20. If the board does choose to certify the EIR, the next steps for the board would be to consider the approval of a statement of overriding consideration. That is where the board will weigh the public good of the project versus the identified significant environmental impact, in this case, noise. And number two, to adopt mitigation measures. And number three, to consider approving the project. And those are all be included in Resolution 18, which the board will consider if it certifies the EIR here. With that, I will open it up to questions from the board by myself or the CEQA team.
CEQA team. Okay. Questions, board members? No? All right. All right. We have no questions. I'm going to open up to public comment. Let's see. I have 4 blue cards, and I have 5. Thank you. 5 blue cards. I will call 2 of the speakers. Mike Jolly and Ken Levin will be the first 2 speakers.
Hello, trustees. My name is Mike Jolly. I represent Coalition to Save San Marin. We gave Yancey a statement this morning. Our comments regarding the responses that we got on October 7th. So that statement will speak for itself. Tonight, I really would like to bring up the discussion about your August 6th revocation unilaterally of the administrative regs for the stadium. Those were agreed to after 3 public meetings, mutual discussion between the board and the community, and we felt very good about those regulations. We do not feel particularly good about you unilaterally revoking them. We thought they were really for the good of the whole community. Also, you might speak with your CEQA counsel, because I'm not sure that the board went through all the CEQA requirements that is requisite when you revoke administrative regs like that under CEQA as a mitigation issue. So we just wanted to put that in the public record, that we hope you will reinstate the administrative regs. We think they served a fine purpose. We were surprised. It kind of made us feel like the partners in dealing with the board were maybe a little bit very different from what we thought we had with the board, which was a community partnership. We would disagree maybe on issues, but it's okay to disagree honorably, and you're allowed to disagree, okay? But the thing is unilaterally revoking something that you approved and that you stated was good for the board, good for the community, that was a surprise to us, and we really think it was behavior that we'd hope you reconsider. So thank you very much for your time.
I have some handouts for the trustees. If there's not enough, I've got one more here. My name is Ken Levin. I'm speaking tonight to say that I believe the final revised EIR is a flawed document with respect to CEQA, and it does not address Judge Chernus's ruling. I want to give you 3 examples to consider before you vote. My letter number 15 points out 2 areas where Rincon, your EIR consultant, misquoted state law in a way that permitted Rincon to draw misguided conclusions in its final revised EIR. I want to point out a 3rd item that is emblematic of how Rincon dismissed simple comments. Knowing that the EIR is designed to inform, I ask how you can approve a document that is built on falsehoods. Any of you with a smart cell phone can verify what I say in about 30 seconds per each item. Ask yourselves, if I am correct, and I am, do you really want to approve a document you know is flawed? The fastest course of action is to go through the CEQA process correctly and accurately. We're not there yet. I also want to confirm that your board must get permission from the court, what is called a return on the writ, before you can turn on the lights. Why? Because Judge Chernus needs to certify you are in compliance with his court ruling. In Section 3 of the revised EIR, Rincon discusses cumulative impacts, quotes CEQA, and then draws conclusions from its interpretation of CEQA. Unfortunately, Rincon misquoted CEQA as quoted in Judge Chernus's ruling and when compared to the state CEQA guidelines. Rincon omitted the words "or increase" from its quotation. Rincon's conclusions regarding cumulative impacts don't make sense if you add the words "or increase" where they belong. The logic of their argument depends on the error they propagated. What did Rincon say when I identified and corrected their error in my sections 1554? They ignored my correction, and they argued that I misunderstood CEQA, assuming that an increase, those words again, in impacts from more than one project automatically create a significant CEQA impact. The words "or increase" are in the statute, and they can't be wished away by Rincon. More than that, I never mentioned the word significant in my 15.54 writings. What is Rincon talking about? This is crazy making. You are the decision makers. You decide if this final revised EIR informs or misleads. I believe it misleads. In final revised section 3.2, related projects, Rincon quoted section 153.55 of the California Civil Code inaccurately. I corrected their error in my comments labeled 1559. What did Rincon do wrong? They included this phrase in their quote: would likely result in similar impacts and are located in the same geographic area. That phrase isn't in the statute. Rincon goes on to argue in section 3.2 as if the phrase is part of the CEQA statute. It isn't. I can keep going, or I stop. You have copies. I think it's important that you hear this. You want me to go on? Just a couple paragraphs. Okay. I just reviewed my response to 1554, and that's the item I just discussed, where Rincon had omitted the words "to increase" from their version of the CEQA statute. Rincon said nothing in response to my correction, but did argue their case in section 3.2 as if the state statute was written with the extra language they added to their version of the statute. There's a link there in the printed copy that shows you where you can verify what I said. It'll take you about 30 seconds with your cell phone. Lastly, and I won't have time to do this, I was going to show a demonstration with a flashlight that shows that if you have a tall pole focused on a single spot, as that pole comes down in height, that the angle has to change and get wider. And so therefore the glare might be pointing right in this direction from here, but not necessarily up here. Rincon just acted like I didn't know what I was talking about. So in the comments that I produced electronically and submitted by email, and Yancey has a USB copy, I did a geometric proof and to lay the matter to rest. But there's a lot of instances like that where the CIR is not pure as the driven snow, and it is something that you want to think carefully about before you certify. Thank you.
All right, our final three speakers are Ross Sargent, Tony Franceschini, and Larry Scheible.
Good evening. My name is Ross Sargent. I'm in support of the lights, and I thank you all for your public service. A year and a half ago, this board voted unanimously to approve the lights due to their clear and substantial academic, athletic, and community benefits. Since then, NUSD has exhaustively studied the project's environmental impacts, mitigated its effects to the utmost, and installed a world-class lighting system. Indeed, the lighting engineer reports that the lighting system's performance, quote, sets a new worldwide standard for sports lighting with an absolute minimum of environmental impact. It currently has no competition in terms of its superior mitigation and prevention of off-site impacts to the environment and to adjoining properties, end quote. Thank you for your world-class work on this project. Please turn on the lights.
I just want to say, that we've been going through this, I think we started almost 4 years ago, and partnering with the district and that great man, Jim Hogaboom, don't want to bring you down there. He's a good guy. I like that guy. Anyway, I just want to thank you guys for your commitment to our kids at San Marin. This is a bold move. I know it hasn't been easy for you. It hasn't been an easy decision. You've been hearing a lot of different things. But I think you're doing the right thing. And I just want to let you know, I'm telling you, from us at San Marin, we know we have an obligation here once these lights are turned on, if you approve it. We're going to take that to heart. We're going to make sure this is right for everybody who's involved. We want to make this right because, honestly, we're hoping that we can make this kind of commonplace in the county so people could say, hey, this is how this really can work, where Terra Linda can do it, where Redwood could do it, where I don't know if Drake High School could do it, but where a lot of these other high schools can put these lights up and make it happen for all these kids in Marin County because they need it. They absolutely need it. The other thing I just want to say, these are great times in Novato Unified School District. A lot of good things happening at Novato Unified. A lot of great things that I don't have kids in there anymore, but I have a grandkid coming in here soon, and well, soon, whatever, 6 years. Anyway, but I'm excited. I'm really, really excited. For the first time since I lived in Novato, some great things are happening, and you guys, you're the reason. And I just want to tell you, I just want to say thank you very, very much. Thank you.
Good evening. My name is Larry Scheible. Once again, we were presented with another version of this EIR containing major flaws. As in the past, instead of addressing the problems, we get the same response to our comments, which is simply, we know better than you do. A major problem that appeared during the lights test was the impact of the upward-facing lights on the hills surrounding the stadium. These unshielded lights are pointed directly at residential neighborhoods, parks, and open space areas in the hills. They produce unacceptable levels of light spill and glare in these areas. In addition, the sky glow they produce far exceeds the acceptable level in the international standard CIA 150 that the district has chosen to evaluate the lighting system. The light spill readings obtained at the site did not reflect any of the impacts of these upward-facing lights because they were all obtained at elevations lower than the mounting heights of the lights. The very obvious spill light on the back of my house should have been a clue to the consultants that the light readings they were obtaining below my house were inadequate. All of the neighborhoods surrounding my house and the entire south face of Senior Hill was lit up by the upward-facing lights. Re-aiming these lights will not solve the problem, but will simply shift the worst impacts from one area in the hills to another. I hope you will not certify this revised EIR tonight, but will instead instruct your consultants to address the very real problems with this document and the lighting system. Thank you.
All right, that concludes our public comment for this evening. Yancy, come back up. This case will come back to the board and see if the board has any questions that may have surfaced, arise, comments. Student Elizabeth, anything? No? Okay, thank you. That's fine. I just want to make sure I include you in there. Thank you for being here. Yeah. All right, if there's I'm looking, no further questions or comments. Do you have anything else to add? I'm assuming you're good.
I don't have
Okay.
anything to add.
So before us is item 9A on our agenda this evening. It's approval of, staff is looking, the recommendation is approval from the Board of Trustees, Resolution 17, 2019-2020, certifying the completion of the final environmental impact report for the San Marin High School Lights Project. So
Madam President, I would like to move the approval of Resolution 17-2019/2020, certifying the completion and the final environmental impact report for the San Marin High School Lights Project.
okay, so we have a first by Trustee Nell. Second? Okay, so we have a second by Trustee Mack. All those in favor? 6-0, 1 absent, and we have 1 provisional student trustee vote. Thank you. Okay, the other item before us this evening is 9B. There's two items here. The staff's recommendation this evening is, this is Resolution 18, 2019-2020 for the Board of Trustees of the Nevada Unified School District approving the San Marin High School Stadium Lights Project, adopting a statement of overriding considerations and support thereof, and adopting a mitigation monitoring report. The second item is the San Marin High School Stadium Lights Project itself. And we can put that as
A
single motion.
motion.
Okay. Is there anything we need to, any comment you want to make before?
Yeah, I just wanted to make a very brief comment. What staff is recommending and for the board to consider is, number one, a statement of overriding consideration. And that's where the board weighs the public good of this project to the students, the school system, and the community versus the significant environmental impacts identified in the EIR, namely noise for this EIR. With that, it would be required to approve the mitigation measures from the EIR, which, as most of them were construction related and others final photometrics, those are now complete. And the last is, from a CEQA standpoint, approving the project. So those are the three key things that are in the resolution, but obviously the resolution speaks for itself.
Okay. Thank you. So this is another action item for this board.
I'd like to make a motion, please.
Okay?
I'd like to make a motion for two things. One, to approve Resolution 18-2019/2020 for the Board of Trustees of the Nevada Unified School District approving the San Marin High School Stadium Lights Project, adopting a statement of overriding considerations and support thereof, and adopting a mitigation monitoring plan. And two, the San Marin High School Stadium Lights Project.
Okay, so we have a first by trustee Mack. Second,
I will second that motion.
okay, thank you, trustee Nell. First by trustee Mack, a second by trustee Nell. All those in favor? Okay, 6-0, 1 absent, and one provisional vote by student trustee DeRuvo. All right, that we've already.
With lights and I mean with cameras, and so just wanted to say that we're being recorded,
Oh, okay.
so that we're on YouTube also.
All right. Thank you. I was like, we just voted. All right, so that concludes our meeting this evening. Our next regular scheduled board meeting is October 15th, which is this coming Tuesday. This meeting is adjourned.